We are calling on the military authorities to, as a matter of urgency, identify the soldiers responsible for the unlawful abduction and kidnapping of Comrade Chidebere. Yes. The law prescribes a punishment of not less than 2 years for such officers responsible for these acts. Pleased.
Very well, please.
He is a victim, or was a victim, of forced disappearance until today. The young man was kidnapped in Abuja here, in broad daylight, without due recourse to the rule of law.
Yes.
Nobody in this country, either the governments, the military, or the police, has the right to forcefully abduct any Nigerian and force him to disappear without recourse to the rule of law. An arrest cannot be enforced or carried out without proper administration compliance with the rule of law. Where a Nigerian citizen, freeborn, is abducted in broad daylight without access to his families, to his children, to his lawyers, and to his doctors, that amount to forced disappearance, and this clearly violates every non-national and international law. The abduction of our brother Comrade Chidebere till today clearly violates Chapter 4, Sections 35, 34, and 41 of the Constitution. And likewise, it also violates the African Charter on Human and People's Rights and the UN Convention against forced disappearance of persons. And there are penalties that were prescribed in these laws against persons, either state agents or state actors, who embark on such an unlawful acts. We are calling on the military authorities to, as a matter of urgency, identify the soldiers responsible for the unlawful abduction and kidnapping of Comrade Chidebere. Yes. The law prescribes a punishment of not less than 2 years for such officers responsible for these acts. The Anti-Torture Act of 2017 clearly prohibits it. And several other international laws. So we are calling on the authorities to, as a matter of urgency, and Nigerians are very, very interested in knowing the persons who embark in these unlawful activities. Comrade Chidebere is not a criminal. As far as we are concerned, and we maintain this to this moment, that Chidebere has committed no offense under the law. Freedom of expression and the duty to expose corruption in every sector, either in the army or in the police or in every other sphere of our national life, is a fundamental right and responsibility of Nigerian citizens. As an activist that Comrade Chidebere is, he owes an obligation under the African Charter to ensure and commit his time and resources for the advancement and the betterment of his country. This is what he has done by exposing corruption and the unfair treatment of Nigerian soldiers who are laying their lives daily to secure our lives and properties in this country. That in itself is not a crime. The attempt to gag the media space we've maintained should never be embarked upon by these governments. Having elected to embark on this terrible cause, we call on the government to desist and stop. Fortunately, they have decided to file a 4-count charge against Comrade Chidebere Mark.
3 counts.
A 3-count charge against Comrade Chidebere Mark. Well, we're in the process of completing the bail application as far as that matter is concerned. The wife is in court here with us, and we are filing a proper motion for his bail as ordered by the court. We have also applied for an abridgment of time within which to seek for his expeditious release. The law presumes that no matter the weight of allegations against a Nigerian citizen, he is presumed innocent under the law. As far as this trial is concerned, Comrade Chidebere is innocent of all of those allegations against him. We will ensure that we also serve the DSS with this bail application before the close of work today, so that my Lord can graciously come back either on Thursday, Friday, or worst case on Monday to hear this bail application. Comrade Jidibere was whisked off from his wife and 2 young children on the 26th of April in Abuja here. Since that date, he has not had access to his wife and his 2 children. This clearly violates the rights of Comrade Jidibere and his 2 young children to right to family life as guaranteed by Section 37, Chapter 4 of the Constitution. So we are urging the authorities that despite the court process, particularly the AGF, now Section 175 of the Constitution, which gives the AGF the powers and officers under his command to institute legal actions, clearly stipulates that there is a procedure that such actions must be done in tandem with public peace, with the interest of the public. What interest will this instant charge filed by the DSS, who has no business in the disputes between the military authorities, who has been stealing the funds, the money set aside for the army to feed in the war front? Of what business does the DSS have with filing a charge in the first place? What business does the military have, or does the DSS have, in filing a charge under the Cybercrime Act?
What national security does?
Is the DSS one of the agencies, prosecutor agencies in Nigeria? They are not. The DSS has no business, has no right to file a charge under the Cybercrime Act, particularly Section 24 of the Act. These are matters that are clearly within the purview of the police, and before such a charge can be filed, the police must first carry out a proper investigation. There must be an investigation report indicting him for committing such an offense. But however one looks at it, a charge under Section 24 of the new Cybercrime Act, which clearly only stipulates that a Nigerian citizen has exposed corruption, should not have been in the first place. So we are calling on the AGF to, as a matter of urgency, exercise its powers of nolle prosequi and discontinuance in this matter. This matter should be withdrawn from court, and this matter should not be in the public space at all in a democracy. Thank you.